It's always going to be based on personality more than anything. And so I've worked with many professionals, over the years, and I kind of know how they work with clients, what their approach is. Some are very business, buttoned up, don't have a lot of, interpersonal communication with the client. There are some clients that really need that. If there's a client that needs hand holding, and that's okay, if they do, that's not a big deal. I understand this is a very stressful period, and you need to have confidence in the people that you're working with. And so if there's someone that's going to be spending a little bit more quality time with the client, then I know, the two or three that I have in my basket that I can deploy for that particular case. If these are hardcore business people, I'm just going to give them the hardcore business person because they speak the same robot language and they don't care about emotions. They don't need handheld. They just need an answer as quickly as possible. So personality is going to be the first touch point. And then for me, in terms of managing it, there could be some complication in how the experts are actually retained in the case. And this is not just true of mediation, it's also true in the litigation world. So sometimes the client directly engages the expert. There is some circles of thought out there that if the client does that, then that expert's work is not protected by attorney-client privilege because it's not part of the attorney relationship. It's just another relationship that the client has that doesn't come with that protection. So a lot of the time, I will retain the expert myself. I'm not going to pay for it, of course, but I'm going to, my name is going to be on the engagement letter. They're working with me, and thus attorney-client privilege applies to the work that they do. So I'm usually going to manage it from that perspective, where I bring in the forensic as a joint forensic or joint CDFA or whatever for both parties. I would be involved in the communication between the parties and the expert, the financial expert, to the extent that I need to be. But I don't need to get involved in those kinds of details if the expert and the parties are working on it fine and they don't need any input from me. But if they do, I'm happy to give it. I just try not to step on expert toes. They're the ones that know what they're doing. I'm just superfluous to their process. But I definitely want to make sure that they're covered by the privilege question. Lori working with just wife in that case, and not so much working with husband. Husband didn't need that kind of process. That in some situations might cause a little heartburn on the other side, because now they think that, now wife has this expert person that she's hired, and now I'm getting ganged up on in the mediation. So the only way to manage that really is to make sure that all of the communication is fully transparent, that the expert is corresponding, even if they're working primarily with one of the parties, not the other, that everyone is getting the information that is being delivered at the same time, and that person is invited to participate in the conversations with the spouse that really has all the questions. Now, whether they decide to participate or not is on them, and usually they don't, but that's a way that we can create sort of an environment where they don't feel as if they're being ganged up on, or that we're aligning all of the forces of evil against them, and we're trying to booby trap them, because that's not what we're doing. And again, as the person in the middle there, I am going to be very sensitive during the course of the mediation to knowing that everyone is feeling okay with the experts that we have hired and the work that they're doing. If it's more with one party than the other, that is definitely on me, and I take that very, very seriously. These two folks we had, they were married for 24 years. Husband was the high income earner. He was making upward of, healthy 7 figures. Wife was, for the most part, stay at home when the kids were younger. When the kids kind of got into, junior high school, she did transition back into the workforce, and she was making a pretty good income too. She was in the mid 6-figure range. So we still had, support issues that we were going to have to talk about. We had a lot of different investment accounts that those two had put money into. This husband was a commission-based guy. So a lot of the money that he had coming in, you couldn't predict, and would be, quarterly at best. And it would be, tens of thousands of dollars, in a swoop. So, and that money would get deployed in all kinds of different ways. And so, of course, the parties didn't talk to each other much about how the finances were being managed. That is a typical, somebody is going to do all the financial side, someone is going to do the household care, and we'll never talk about it. We shall never speak of this until we don't get along anymore and we have to have a divorce, and all of a sudden I don't understand how the money works. And so a lot of disentanglement of the last really 15 years of, financially managing the community. The first expert that we got involved in this case, because the property issues, even though we still had kids in high school, they had almost graduated, but we had some custody issues, but those weren't forefront. We were talking mostly about the property stuff. And so the first thing I did was reach out to a certified divorce financial analyst at CDFA down in San Diego. Her name is Lori Itkin. She is absolutely the best. And she does work with parties that, want to know what their property division might yield them in terms of return of that investment. However that turns out, if there's a way to deploy what they get in the property division in a little different way. If there are issues about trying to figure out what income really is, if you have a kind of an interesting, different, like non-W-2 kind of job. And she does a very, very good job of advising the clients very realistically as to what they can expect when, the divorce is final, and, how to figure out what a reasonable support number is. And so we tasked Lori with kind of working through some of the issues with regard to just pulling apart those accounts, and in trying to give some guidance to the client about really what was at stake here, where was the money going, right? And I think she did a pretty good job of that. And so out of that process, we got a very lengthy spreadsheet. There was some historical information that got reduced to kind of like a graph that showed where money was going, into what kinds of accounts, how that money was used, if that money still exists somewhere, things like that. There was an inheritance that was received too early on in the marriage, which was a further complication because inheritance money is separate property, right? It's not community property, but the inheritance fund got basically commingled almost to the point where you couldn't distinguish any of it anymore, although we did get some of it. That's not work that Lori did, because on that front, we had to get a forensic accountant involved. So a forensic accountant is different from a certified divorce financial analyst. Some forensic accountants do similar work, but mostly what they're there to do is identify like a business interest that maybe needs to be, valued for purposes of dividing that interest in the divorce case, or is going to be handling some of the more complicated tracing issues. And that's when we have to trace, separate property or community property funds to a source from years in the past, and then follow it forward to see kind of where it's deployed now. CDFAs can do that kind of work too, but it's not unusual for a forensic accountant to do that. And this case was so complicated that we got a forensic accountant involved to kind of help us out on the tracing work. And that was good for husband, because although he was the one that was putting the money in all these different pots, had no real central plan. So it was a little haphazard, and he didn't really even understand where all the money was going. There was a lot of it, great, but again, when we're trying to identify how to divide this stuff up, what's separate property, what's community property, you got to pull all that stuff apart. And there was some other separate property stuff that had gotten into the mix over the years, and so that was some work that the forensic accountant did. We did get all that stuff lined out eventually. It took a while. That's a several-month project, and it's not inexpensive. Sometimes you can have an expert that comes in and just kind of reviews an approach, like a theoretical approach. If I'm saying, hey, here's what I think here's how I think we might be able to value this business. Here, there's different approaches from the forensic side that you can take that will give you, some hint of what the value might be. Book value, income, asset approach, lots of different kinds of approaches. And a forensic can look at that and say, yeah, great, that makes sense. Here are some thoughts, X, Y, Z. Maybe we pay that person $1,000, to do that review, kind of the source documentation, but it's not a full forensic accounting. In this case, that was a pretty close to a full forensic accounting, even though we weren't valuing a business. So that was, I think they ended up paying almost $10,000 for that piece. And, Lori is much more affordable, but again, some of this stuff was beyond what she had been hired to do. That's another couple $1,000s that went her direction. But we did get all the property stuff out on the table. We understood kind of, at least we had a better idea, a clearer idea of what the values were, if there was going to be any recapture of some of that separate property, which there ended up being, which was good, and I think worth the investment. And we got an agreement on the property stuff, which was great. But that, again, those kinds of things in a mediation, that's not going to get you, out the door in 2 months, which is about what my average is. This was, an 8 to 10 month kind of case. It just was, right? And so we got the property stuff done in about 6 months, and then it was custody time. With regard to how to look at issues like this, that we look at them through the best interests of the child always. And so we always have to back up. And if we're feeling like we want something because it's more convenient for us, if it's easier for us to go pick up the kids at school, if it's easier for us to get them to, their extracurricular activities, whatever, then that's what I want to do. As opposed to saying, well, they have friend groups that have been established here. They've been on this traveling soccer team for the longest time. They're not going to be able to be on that traveling soccer team if they're in this different area. It just wouldn't work. Aligning them so that they're both thinking about that is your first job as a mediator. And I did the best job I could, but I could not get them all the way there. And so, my background is not mental health. I'm not a licensed clinical social worker. I'm not a marriage and family therapist. That is not what I do. I mean, mediation feels like therapy a lot of the time, but I will tell you it is not. I do not have the experience to be, therapizing clients. So I suggested maybe having someone that the kids hadn't been in therapy, but therapy was not a new thing to this family. Getting a therapist involved and getting their thoughts. So with therapists, there are different kinds of therapists. You can just get a private practitioner. That's just somebody out in the community that the parties know, either they've worked with before, or sometimes the kids already have therapists. And sometimes you just say, hey, look, we want to put this question to this person. We want to see if they will talk with us about, how they feel. Some will not, because the child is their client, right? Yeah. And they are covered by confidentiality. So sometimes they'll just say, even if you sign a release, I'm not going to talk to you. Some therapists will do that under, very specific, conditions that, that both parents have signed a release. That they're not going to be involved in the mediation. They're not going to be, assigned to, tell the child what the child should do. There should be some conditions around that clearly, but that's with a private practitioner. You can also get someone that will come in as a recommending counselor. So this is, and this needs some work on the actual legal, on the court side, where you hire someone to be a private child custody recommending counselor, right? And so they will have the authority from the court. You just do what's called a stipulated order to a private child custody recommending counselor. That goes to the court, and then they will, report back on the custody issues. So, which is weird because we're supposed to be staying out of court in mediation, right? The thing about custody and the court and mediation is that the court is always going to retain jurisdiction over the custody issue because it's so important. So even though you come up with an agreement in mediation, that doesn't mean that the court isn't going to get involved at some point. It also doesn't mean that the court's not going to look at the custody agreement and say, I don't like this because I don't believe this is in the best interest of the child, and they reject it. So you've got to be, careful about the line that you tread in, in the mediation sphere when you're working on custody issues. So even though it sounds a little strange to get, a court-appointed expert involved, it does make some sense if we want the, the custody agreements at the end of the day to be, as bulletproof as they can be. So then we get that person involved, and that person interviewed the kids, that person talked to both parents, both together and separately. And and the great thing about it is that the recommending counselor got the parties to a full agreement on the parenting issues, which took the laboring oar out of my hands, which was great, but more importantly, got the job done for the kids in a way that really was very child focused. I probably work with this kind of expert more often than any other, and that is the consulting attorney. And this is outside of the mediation room for the most part. When we have two people that are technically not represented, like I did in this case, and they're trusting me to be forthright and transparent and all the legal niceties and what I think about the agreement that they're proposing or the creativity that I bring to the process, that's one thing, and that's fine. But I can't be held responsible like a lawyer can be, right? Because the only thing that matters to the state bar and the mediator is that they're neutral, right? So as long as I can be neutral, I can say whatever I want, really, and they can't hold me accountable for that. They can't sue me for malpractice. That doesn't mean they won't try, but it means they're probably not going to get very far. Now, I don't want to put anyone into a position where they think they need to do something like that. I mean, that would be bad for client relationships. But the way that we kind of backstop that to give them some security that the agreement that they reached is a good agreement is by having each of them have their own, consulting counsel, not representing counsel. These are just people that are going to talk them through, proposals as they come up. If there's, a mediation that we had a couple hours, they'll go then consult with their attorney and say, okay, here's what happened. Any thoughts? What should I be, thinking about? What do you think about this cockamamie idea that Neil came up with? All the things, just to give, the client some security that they've got somebody on their shoulder that's looking out for them. And ordinarily, when I've got one client with a consulting attorney, I want the other client also to have a consulting attorney, even if they don't use them. And they can pick whoever they want, although I tend to steer them away from hardcore litigators because a lot of the time they don't really believe in the mediation process at all. They think that mediation is a joke and that you're going to end up in court anyway. So all of this is garbage. So I try to make that clear in a more friendly way to the clients when they go out there, that they really should be looking for an attorney that, when looking at their website, it's clear that they're settlement focused. Stay away from those kinds of attorneys and find someone that's got lots of experience, but also understands the value of settling. And have those two, kind of on the side and whispering in your ear. Now, we could also have those consulting attorneys involved in the mediation itself. If the parties want to bring both of their attorneys to the mediation room, they absolutely can. It's just going to increase the cost, right? Because they're going to have to pay for the attorneys on their own dime. And, it's going to make the conversation much more convoluted and maybe lengthier. The goal, however, in every case is to have a stable agreement at the end. And if stability requires that we have that kind of input from the attorneys, then I welcome that. I have no problem working with attorneys as long as they're all on the same page with me that we're trying to get to something that resembles a stable agreement at the end. And so these two folks in the case that I worked on both had consulting attorneys. The consulting attorneys did a very good job of reviewing all the paperwork. They, highlighted some things in the draft of the marital settlement agreement that we needed to discuss a little further and make more clear. So their edits were very, very helpful. They did not upset the apple cart in any way. And we didn't need to meet together with them in the mediation room. And they did a really good job of managing expectations of their clients, which is another thing that they can help with. Sometimes all that stuff gets dumped on the mediator. And it's not my role, to make sure that someone feels good about the agreement and that their legal rights are being protected. That is not my goal. If I did that, I would no longer be neutral. And
Right.
what happens with a non-neutral mediator? You get sued.
Sued.
So we don't want that. And again, that's not the process. And so, that case had it all, right? I mean, there was a lot of experts involved. We got everything done eventually, but it took a long time. And the parties left relatively satisfied with the result, and I'm proud of that work.